Good morning, everybody. My name is Marco Ventura. I'm also a scholar in law and religion. As Chiara mentioned yesterday, we have our distinctive interest and take on our subject matter. I teach at the University of Siena at a law school, and I also have the privilege to work in a private foundation here in Trento, FBK, Fondazione Kessler. So let me start by expressing my gratitude to Professor Toniati personally and the faculty here and the University of Trento for this opportunity to be with you for this workshop and to learn a lot already from yesterday's session in many regards. Before giving the floor to the speakers for this morning, I would like to say a few things on my side about our work. And I have 4 things to say, 4 points, starting from the first one, which is that we're dealing with a matter which is extremely relevant for the life of many. Of course, as lawyers, we are passionate about technicalities, we are passionate about concepts, we're passionate about political dynamics, but at the end of the day, what we're talking about here is something which is extremely concrete, down to earth, for the life of many people, men and women. And when we discuss talaq, when we discuss inheritance and shares and men and woman equality or gender equality or sexual orientation rights or everything which pertains to the life in a family, to the life in a marriage, or to quitting a marriage, including very often violence in a marriage in many different forms, well, this is what we're talking about here. And this is why this is so relevant a discussion in our respective countries. Now, having a focus on the significance in the everyday life of people may help. Although linked to that practical relevance, we also have a high symbolic relevance. Both are important. Symbolic issues related to especially religious belonging can be as practical, as dramatic in the everyday life of people as issues related to alimony, shares of inheritance, or property rights in general. Second thing I would like to share with you is that we combine, thanks to the very wise design of the workshop, we combine a country-based approach to comparative perspective. Yesterday we worked on India. Today we will work, thanks to Francesco and Arif, on Pakistan, Bangladesh, and, well, countries in Southeast Asia in general, starting, I suppose, from Singapore, where Arif is from. This focus on countries is extremely relevant because of historical legal developments which made for the state and the nation state to become the main legal actor. But, of course, these developments are also extremely relevant in terms of the interconnected world. We're all learning how to cope with this twofold dimension. A focus on individual countries and an effort which needs to be put on understanding the local specificities with countries and within countries, while figuring out how to best understand and manage the interconnected dimension, which makes then for the national and intranational dimension to be relevant in the international, supranational conversation. Here, our exercise, my third point, is, as we learned yesterday by means of methodological remarks from all the speakers and the Chiara Lapiner discussion, we confronted with the need to gain a solid grasp on both reality and technicalities. Reality and technicalities. That's a, well, difficult exercise all the time for lawyers, but lawyers, well, good lawyers know that that's what the knowledge is about in the first place. Now, my fourth point is this leader, which, as you see from the date, 28th of April, is just been published in the Tribune, published in Chandigarh, by a highly respected and authoritative colleague. Faizan Mustafa is a Muslim himself, vice president of the law faculty, Law University, as they call it, in Hyderabad. And he's publishing today, he sent me overnight these articles. As you can see, this comes straight from my email, telling about the decision of the All India Muslim Personal Law Board recently, a few days ago, to issue a code of conduct for divorce. This code of conduct, I will share this text through Professor Toniati afterwards. This text is also extremely helpful because it includes a summary of the 8-step code of conduct. We don't have the time now to go through the 8 steps. What matters going in getting closer to the heart of our matter is that this is clearly a reaction from the Muslim community, from a, let's say, one extremely important legal constituency within the Indian Muslim community, to react to the triple talaq issue by the decision to issue for themselves a code of conduct in case of divorce. And the author of the article comments in these terms, as we can see on the side on the left. This results in a major clampdown, and the All India Muslim Personal Law Board has considered ground and resolved in favor of one divorce. Therefore, according to the author of the article, instant triple divorce will no more be an option with a Muslim male. Of course, whether this should be true or not, it's still a matter of speculation and discussion. I suppose that this is certainly not done in India in terms of this debate, but it's interesting for the sake of our conversation to pay attention to the fact that there is an initiative from within the community, a legal initiative, which is also based on data. This is my point about a grasp on reality. The author has a special pays a special attention to data on divorce, and especially to the fact that only, as we read here, 0.2% get divorce over the phone, or 0.6% through email, according to the findings of the survey which has accompanied the elaboration of this code of conduct. The very triple talaq, resort to triple talaq, is extremely rare as well. According to the author, we read here the resort to triple talaq is really 0 point something overall. Now, before giving the floor to the speakers, let me read a passage from the text, from the leader, which will serve as introduction to the morning session. The reform process, according to Faisal Mustafa, will indeed be painfully slow. When reforms come from within, there will be greater acceptability of reforms. We must realize that if the people in the family and neighbors consider that divorce has taken place, may declaration by the Supreme Court that it has not taken place would not drastically change the ground situation. Law is not a great agent of social control, and we must accept its limitations in bringing about social change. Things which society considers illegal, law on its own cannot easily make them legal. Similarly, what society considers legal, law cannot make illegal. Poor implementation of Dory laws is a case in point. Is he right? Is he wrong? Well, that's by all means, in all respects, this is the art of the matter for us. It was so yesterday, it is so this morning, and I'm now giving the floor with the gratitude, of course, of all of us for them having accepted to prepare two presentations to the two speakers this morning. They will speak for 30 minutes each. As we did yesterday afternoon, same format. We will have coffee break immediately after their presentations. We will then resume, and we'll have time for the discussion of Professor Amirante, whom I also warmly welcome and thank, and enough time for all of us to engage in a conversation and Q&A. Thank you so much. You have the floor.
Thank you. Thank you, Professor Ventura, for those introductory comments. Let me start by offering my thanks as well to a number of people, to Professor Toniati and Dr. Srazari for organizing this conference, and to yesterday's presenters for the rich discussion that we had, a very kind of important start to the discussion. I wanted to begin my comments this morning, before I turn to the substance of my presentation, by just making a few prefatory remarks. Professor Ventura said in his comments that you've just heard a couple of things which are very relevant to what I want to say. We didn't plan it in advance, I assure you, but I was very glad to hear it. One was a comment about the importance of this issue, both generally and globally. This is not just something of the South and the East. It is increasingly being something of the North and the West for a variety of reasons, one of which is demographic change, and that might be particularly the case here in Italy. The second point that he made was the question of symbolic importance. And I'm going to come back to this near the end, but we lawyers can sometimes perhaps be a little bit tone deaf to the importance of symbols. Perhaps not, because we do use symbols as well. We engage in certain forms of art. We create legal fictions which are important to us, whether it's the way judges dress, or how they sit in a courtroom, or the fact that we have, the Statue of Justice in front of courthouses, and she has to be blindfolded and holding these things. We have our own symbols. But sometimes I wonder whether or not we are alert to the symbolic importance of things outside of just our legal symbols. The third prefatory comment, I want to pick up from what Professor Francavilla was saying yesterday about the challenge of diversity. A diversity which might be expressed as religious diversity, which might be expressed as cultural diversity, or as normative diversity. And this challenge is a challenge, at one level, a challenge that has always been there in history. But at another level, it is a challenge that we are feeling more, I think, now, because of our mindset of modernity, which, on the one hand, a lot of us who might think of ourselves as kind of liberal-minded progressives would think, well, of course, diversity is a good thing. Right? It's a given that it's a good thing. But as Professor Francavilla pointed out, diversity comes with a great deal of challenge. We might have to use his language again, which I will come back to, the question of good and bad complexity. And the challenge of, again, to pick up on his comments, of unlimited pluralism. And how can we move from diversity to unity and back again? How do we find this balance? And finally, I wanted to draw upon the idea that perhaps what we are looking for, what we are searching for in so many parts of the world, is a form of, he gave an analogy to language, to the rules of language. When you talk about the dealing with unlimited pluralism, and it's one of these things that sort of changes generationally. Yes? So nowadays, since we all use these devices and we're using WhatsApp and other sort of programs, the way in which a language is written has changed. And sometimes it still annoys me, and perhaps this is a function of age, relatively speaking, when I will get emails that are written as if they're WhatsApp conversations. Right? It's not with, it's W. It's not Y-O-U, it's just U, just the letter U. Right? Now, why does it bother me? Or why does it concern me? Well, it concerns me because somebody might say, but that's just a new way of expressing the language. That's just a new way of writing English. You should be happy with, the plurality of English expressions. But it strikes me that there is, what concerns me, of course, is that, we might be losing something in this unlimited plurality. And perhaps we need to have, like a language needs to have rules of grammar. You can't just structure it anyway, because otherwise it becomes not a harmonious thing, but it becomes a cacophony. You can't hear it. You can't make sense of it. So too, by way of analogy, I am suggesting that we might be thinking about, and I'm going to give my own suggestion about how this might work, but what we might be thinking about is a legal grammar to deal with this challenge of diversity. And how to deal with this question of good and bad complexity and the challenge of unlimited pluralism. And finally, I'm going to try, near the end of my presentation, to talk about productive potentials. This is a part of the title that is in the program. I've modified the title just a little bit for my slides. And I'll come back to the varieties of different productive potentials that I want to talk about. So onwards to, as it were, the case study. Which is not working. All right. So what I'd like to really do to organize my presentation is to talk about three things. I'm going to talk about the context of Singapore and the region of Southeast Asia a little bit. This is by way of some data to give some demographic and other context. I want to talk about varieties of legal pluralism. And this is part of the normative argument that I'm going to try to develop. And that links to the end, the question of productive potential or productive potentials of legal pluralism and of personal law regimes as expressing legal pluralism. So let me start with some of the context. Those who are familiar with Southeast Asia may know this. This is some demographic data. In fact, I'd used some of this data when I presented at the conference last year in Singapore, so anybody who was here might think it's the same information. Of course it is. It's the same. It's the same data. But let's just take a quick look at it. So as Professor Ventura said, I'm based in Singapore, so I'll kind of be mostly talking about the Singapore context, but this other gives you the sense of the region. And you will see that there are two things that might strike you about this region. One, for those who aren't familiar with it, is the diversity of different traditions that are there. The different form, the second thing might be the different form of the diversity. Right? We are now in a European space. This number here, under here, would have been the largest number in the European space. It's a minority, of course, when you're talking about Southeast Asia, right, and percentage of Christianity. And the second thing is the numbers of people who, at least in this survey way, this accounting is, have religious affiliations. The strong levels of religious affiliation. Right? And if you looked at European figures, and Professor Ventura can correct me if I'm wrong, there is still a substantial plurality of European citizens which, when asked if they have religious affiliation, say, we do have religious affiliation. That is declining somewhat over time. And the percentage that would say they don't have religious affiliation is fairly high. I mean, by international standards, fairly high. In the 20s, up to maybe the 30%, depending on which country you're looking at. Okay. Northeast Asia, which I'm not going to talk about, actually raises some interesting questions about this, but I'll leave that for another time in terms of people not expressing religious affiliation. So here is the demographic, and you can see, at least in Southeast Asia, when you look at Malaysia, Indonesia, and Singapore, significant Muslim populations, and of course in Thailand and Singapore, significant Buddhist population numbers. Okay. Looking at Singapore, I'd like to ask you to look first at the bottom row, the no religious affiliation. And one of the things you will see is that this number is increasing. Right? It's gone from 14.8% to 17%. But if you look at the other figures, you will see the sort of breakdown in the country, and this breakdown is also mapped, roughly speaking, onto ethnic communities. The Malays are overwhelmingly Muslim. You can see the numbers 99.6, 98.7. Among the Chinese, among the Indian population, you have a split between those who are Hindu, those who are Muslim primarily. So you talk about Indian Muslim and Malay Muslim in the context of Malaysia, I beg your pardon, in the context of Singapore, but also in the context of Southeast Asia more generally. Higher numbers of Buddhists and Taoists among the Chinese population and Christianity. And interestingly, if you look at these numbers, if you look at the Chinese population, 2000 Christian percentage 16.5, then 2010 it goes up to 20.1. That's a pretty large increase. And similarly, the Buddhist Taoist population, 64.4 to 57.4, is a not insignificant decrease. And some of this is the influence of how people are defining religion, right? So, and which religions are attracting attention. So this is the breakdown, just to give you some of the demographic figures. And again, this is a similar sort of thing. This shows distribution by religion. It's a little bit easier to read. Distribution by religions in Singapore. Again, one of the things to notice is the difference. If you look at the lines on Buddhism and Taoism and traditional Chinese beliefs, you'll see that Taoists go from 80% in 1980 to 8.5% in 2000. What happened? Did we expel all the Taoists? No, we didn't. Why has Buddhism gone up from 27% to 42.5%? Did we import more Buddhists? No. What has happened here is a question of identification. So sometimes over time people think that Taoism is not a religion, but Buddhism is like a proper religion, so we're Buddhists. Right? Okay. Again, you can see the percentage of Muslims, not much change. Christianity, fairly significant increase. Hinduism staying about the same. And no religion actually increasing over time in Singapore, right? From 13 to 14.8%. And this is now in the 2000. In the 2010 or 2015 survey, it's gone up even higher. It's gone up to about 17%. I don't have those figures with me. Okay? Now, what does this mean for the region and its context? Well, in a recent survey, this is the 2014 survey by Pew, which is one of the major American sort of surveys, the survey companies that does this work on religion. They looked at religious diversity, and what they found was the region of the world with the greatest religious diversity was Asia Pacific. And the country in the world with the highest religious diversity was Singapore. But in the region, you can see that there are very high scores for religious diversity. Now, religious diversity, let me be clear about this. Religious diversity does not mean religious affiliation. Religious diversity includes those that do not express religious affiliation. It's how diverse is the population, how religiously diverse is the population. So Singapore, they said, was the highest in the world in terms of religious diversity. But as I said, if you look in the broader region, Taiwan, Vietnam, South Korea, so this includes Southeast Asia and some Northeast Asia, several countries have very high religious diversity. Malaysia has high levels of religious diversity. Okay, there is one thing that both of these, this slide and the earlier slide, don't tell you, but which I would like to tell you now, and I just couldn't find figures for it. This isn't new in this part of the world. This is old. It is deep. So in Southeast Asia, they use sometimes a metaphor of a rojak society. Now, for those that don't know what rojak is a dish. It's usually got fruits and vegetables and some sort of spicy sauce. And there's the Malay rojak, there's the Indian rojak. You know, in other parts of the world, in North America or in Europe, you might say it's like a tossed salad. Right? It's got all these different pieces. So the idea of the rojak is that it's got this mixing. This mixing is both distinctive, but together makes a dish or makes a society. So the thing about Southeast Asia is that the Southeast Asian rojak is not new. This has been the case for a very long time. Now, this might make the solutions or the ways in which the question of legal pluralism and personal laws have been dealt with in that context different from how they're going to be dealt with in other contexts. If this is inherent, if this is integral to what your society is and has been there for a long time, this isn't some new phenomenon that you're having to necessarily grapple with. This is, as it were, how we were, how we are, and potentially how we will always be. Okay. Right, so then let me speak about some of the legal framework now. Having given you some of the demographics, let me talk about some of the legal framework. So the Constitution of Singapore has these articles about the freedom to profess and practice religion and to propagate it. Okay, so those three elements, profess, practice, and propagate in the Constitution. And then an article that talks about religious groups. So it's not just individual freedom of religion, but also attaching to the group, right, which we lawyers will understand, to manage, to establish, to acquire property, etc. So the right talks about individuals and groups, and the right has these aspects of profess, practice, and propagate. And one of the leading public law scholars, one of my colleagues at the National University of Singapore, Teo Lian, has argued, therefore, that Singapore's brand of constitutional secularism, and let me pause there because the phrase constitutional secularism appears in the title of our program. Notwithstanding what I've said about the demographics, nor what I've said now about the history and what the Constitution says, the government of Singapore, the Constitution of Singapore does not declare Singapore to be secular. But the government of Singapore regularly does. In Malaysia, there is a debate because Malaysia says Islam is the religion of the Federation, but other religions may be practiced freely. That's roughly speaking, the constitutional language. And there is a debate, an ongoing debate, about whether or not, because Malaysian prime ministers and others in political statements have said a variety of things. Malaysia is a secular state, Malaysia isn't a secular state, Malaysia is kind of a secular state. I mean, sometimes it's on Thursday we're secular, on Sunday we're not, Malaysia has this debate. But Singapore, the message from the government is consistent, and that message is, we are a secular state. But what is the form of secularism, or constitutional secularism? And so what Professor Teo has said here is that this form of constitutional secularism is not atheistic, but framed along agnostic or benevolent lines where the state does not favor or disfavor religions, nor favor irreligion over religion. In other words, it is not, because it's often used as a comparator, it's not designed to be laïcité, it's not designed to be laïque, which you might say seeks to favor say, non-religion, no religion over religion. This is a different sort of pattern here. This is in part, I think, as a result of the demographics and history that I've been talking to you about. Okay. Minorities and the special position of Malays, Articles 152 and 153 of the Constitution give special provision to the concerns of the Malay and hence Muslim community. You remember those the demographics I showed you. The Malays are almost entirely Muslim. Why? Well, these are considered the indigenous peoples of Singapore and indeed of the region, right? But certainly in Singapore, so they get special provision, and this, I'll come to this in a moment when we talk about what that means for personal law. So as a result of 152 and 153, you have a series of legal institutions. Professor Toniati talked about legal institutions yesterday. So legal institutions here, one is an act, the Administration of Muslim Law Act, under which there is a structure set up. This includes the Islamic Religious Council of Singapore, or MUIS, as it's known by in its Malay acronym, and in Malaysia, similar structures. There's a different acronym called JAKIM. I can't translate that from the Malay, but it's sort of an Islamic Religious Council that operates as at least a quasi-state body. Okay, you have Sharia courts with a Sharia Board of Appeal, so you even have these appeals. And interestingly, at least for a simple common lawyer like me, the Sharia decisions are now reported. So you're starting to have reported decisions of the Sharia courts, which creates sort of common law precedential structure in a broadly common law environment like Singapore. You also have a committee under this MUIS, under this Islamic Religious Council, called the Fatwa Committee. Fatwa meaning a legal opinion, so they can issue legal opinions on a number of different issues. There is, of course, the question of the interface of the Sharia courts with the civil courts. I've cited one case. There's another recent case that has come out. And in essentially what it means is that the way Singapore structures things is that the regular courts, the secular courts, the civil courts, if you will, have ultimate oversight over the religious courts. I mean, it doesn't seem like that when you look some of the technical material, but that's in substance what happens. But notwithstanding the religious diversity that you saw in Singapore, there are no other religiously defined courts. So none of the other communities have religiously defined courts, Hindu community or Buddhist community, etc. In addition, you have special provisions which you get to personal law. For example, a special registrar for Muslim marriages. So there is a registrar of marriages in Singapore called the ROM, the Registrar of Marriages. And then there is a registrar of Muslim marriages. So Muslims have a different registry for their marriage. They get married in a different way. And under this section of the Women's Charter, which is one of the main pieces of legislation dealing with personal law, under Section 3.4, Muslims in Singapore cannot get married under secular law. That is, if both parties are Muslim. They must get married according to, as it were, the Islamic rite. They must have a Muslim marriage. You have other communities that do operate as well, but they operate differently. They don't have constitutional provisions. They can operate as either societies or sometimes companies under the relevant bits of legislation. And there are state-sponsored bodies, including where the state appoints people for other communities. So the Hindu and Sikh communities have bodies where the government of Singapore will, again, so sort of quasi-state related bodies. There will be state sponsorship as well. But they operate in a different structure. Again, no courts, you don't have the same act, etc. Okay. And since we're in Italy, of course, let's talk about the Roman Catholic Church. There are also bodies or communities, religious communities, that operate under private acts of parliament. And this is an example, the Roman Catholic Archbishop Act, which allows the Catholic Church to operate as a body corporate in Singapore. Right? So a body corporate giving it some sort of institutional capacity to own property, to be distinct from the individuals, etc. And all of this takes place under, there are a series, there are several pieces of legislation that Singapore uses and that other jurisdictions also use to manage the relationships between religious communities and including their personal laws. And I'm just going to highlight one, which is, as it were, the capstone piece of legislation, the most important, the most significant one, which is called Singapore, the Maintenance of Religious Harmony Act. Okay, now there are two things I'd like to say about the Act. The first one, if you look at the title, Religious Harmony, that tells you the model that Singapore is going for. That is the mantra of the government. We are here to maintain religious harmony. But religious harmony is not left to, it's not left as an organic process. There is a concern about managing religious harmony, maintaining religious harmony. And therefore you have a series of bits of legislation, including this Act, which does a couple of things. This Act creates the Presidential Council for Religious Harmony, which brings in various faith leaders, which is sort of a consultative. It doesn't have sort of executive authority, but it's sort of consultative and advisory body. But also it has a series of rather strong, one might even say, depending on how you want to characterize it, excessively strong powers, potential powers, that can be exercised by the minister to police or manage religious harmony. Thank you. All right. So let me, in the last few minutes, move on to the real substance of the argument. I think I've spent probably too long kind of outlining the context. But let me get you to the normative part of the argument I want to make. When we talk about legal pluralism, we often talk about what I'm going to suggest we should relabel a little bit. That either we make sure that we talk about it as descriptive legal pluralism, that legal pluralism obtains as a matter of fact in certain circumstances, or indeed, I am going to suggest what we use a different word, and that we should use the word plurality. Why do I say that? Plurality versus pluralism. Well, isms seem to me to be normative commitments to something. Communism, socialism, capitalism. Legal pluralism, if it is used simply to describe a situation, if it is simply descriptive, doesn't seem to hold that same commitment. Now, I'm not suggesting we shouldn't hold that commitment, but I'm thinking that we should work on our language, moving from legal pluralism, working from legal plurality as a matter of fact, to legal pluralism as something beyond simply the description. By which I mean that legal pluralism would not just tolerate legal diversity, but be a positive normative attitude towards it. It would affirm the normative legitimacy of legal differences and the authority bases for these differences. We move from tolerance to acceptance, right? From toleration to acceptance. If this is what we understand pluralism to be, it does a couple of things. One is, of course, challenges perhaps existing conceptions of pluralism, but let me leave that aside. But I want to talk about how it relates to personal law regimes. Right? So this changing attitude from plurality to pluralism. How do personal law regimes fit into this if we change our normative attitude towards pluralism? And I want to talk about potentials and pitfalls very quickly. Let me start with some pitfalls. There is a real question about whether or not how personal law regimes affect autonomy. Not just the autonomy of a group, but an autonomy of individuals. And a recent work has argued that in fact personal law regimes should be resisted as formal regimes because they undermine personal autonomy. Right? They sometimes validate a group. I gave you the example. Can Muslims in Singapore choose to get married any way they want? No. They have to have a Muslim marriage. So you undermine personal autonomy. Secondly, there are questions of inconsistencies, and I think the Singapore case study shows this up. different communities are treated differently. So the question of how a consistent treatment can be made. Third, the challenge to social solidarity. The question of reasonable accommodation or not. And I think this is a challenge that perhaps Europe is facing now, right? As its demographics are changing, to what extent are personal law regimes corrosive of social solidarity? Do they create these sort of ghettoized groups? Fourth, the question of human rights standards. Professor Ventura already spoke about it, particularly concerns about gender equality. Do personal law regimes, are they inimical to gender equality? How might they fit in gender equality? And finally, the question of management. This comes back to the idea of the ideal level, or the question of how to deal with what we might call unlimited pluralism. How do we manage how do we manage, if we want to manage personal law regimes, how best should we manage them? Particularly to take account of these other things, like the challenge of equality. But I think they also offer some great potentials. And one of those potentials is, to go back to the idea I was just talking about, the move from plurality to pluralism. A recognition of the epistemic, and this goes, I'm going to pick up what Professor Francavilla was talking about, good diversity. What was one of the things that he said that good diversity could do? Good diversity can enhance our normative horizons, enhance our epistemic frameworks. And personal law regimes, when they sit with a different authority basis, when they might draw upon different sources, can force us all and force our legal systems to encounter the epistemically other. Right? It's like that notion of the Platonic gadfly, right? That can be an annoyance, but maybe a useful annoyance, right? Constructively subversive to our ideas. Second, and sorry for the typo, but pick up, Professor Ventura has made this point already, the symbolic importance. The particular symbolic importance in terms of recognition and identity of groups who are linked to these where the personal law matters a lot. To strip away the personal law would be to harm them. And finally, it may be that these can be used in a managed way as a measured response to the political fact or inevitability of diversity. So John Rawls talked about the fact in his Political Liberalism that we live now in societies around the world of irreducible pluralism. We can't wish it away. It's not going to go away. You can't take an eraser and just scratch it out. It's irreducible. And as Immanuel Kant once said, and perhaps Immanuel Kant is a nice guy to finish with, right? The famous quotation from him, "Out of the crooked timber of humanity, no straight thing was ever made." Personal law regimes may be like knots in the timber, but that is part of our reality. Thank you very much.
Thank you very much. I think you keep your promise of giving us some grammar, right? You provided our discussion with a fascinating and complete, in fact, grammar of the topic, embracing facts, an understanding of facts, a grasp on facts, your idea of a Rorschach society, then dealing with the role of government and the role of the state, especially when you mention that the legal system in Singapore is not left to the civil society itself in terms of achieving the goal of a religious harmony, but it implies an hands-on policy from government. And then ending with your discussion of potentials and pitfalls of personal laws, and again, as a matter of grammar, helping us seizing the difference between plurality and pluralism. Thank you so much for your contribution, Professor Jamal. And I now give the floor to Professor Alicino for his presentation of our theme with specific regards to Pakistan and Bangladesh. Professor Alicino, you have the floor.
Thank you. Thank you. First of all, I'd like to thank Professor Tognatti and Davide Strazzari for inviting me. It's a great honor to be here for the second time, actually. Then, given the time available and the subject of my paper, as you can appreciate from the title, I have to apologize in advance because I won't be able to analyze in depth, as I would have liked, all aspects concerning freedom of religion and religion-based personal law in Pakistan and Bangladesh. In any case, it will be a great pleasure to answer your question after the break. For the same reason, I'd like to start by getting straight to the point, which means to the fact that, in my opinion, in order to understand the status of personal law in Pakistan and Bangladesh, it would be instructive to understand the texture of Islamic-orientated policy in these countries. The impression is that ever since the independence, these two legal systems have been hostage to religion-based politics. This is particularly evident with reference to the personal law, in respect of which there has been a constant undercurrent of strain between modernists and traditionalists, sometimes giving the army an opportunity to take full advantage of the situation. The recent history of Pakistan is, in my opinion, the best example of that. The separation from India in 1947 did not happen only between Pakistanis and Indians, but also between Muslims and Hindus. As a matter of fact, this was not only a political conflict, but also religious, cultural, and social struggle, which is reflected still today into some provisions of the Constitution first approved in 1973. After a second period of martial law, a civil war, and the separation from Bangladesh, the 1973 Constitution, Pakistani Constitution, was implemented as a part of a new civilian government. The Charter formally established Islam as the state religion, also retaining the retroactive clause of the 1962 Constitution requiring that, quote, all existing laws shall be brought into conformity with the injunctions of Islam, end quote. In addition, in 1973 Constitution created the Council of Islamic Ideology to enforce implementation of this clause. Articles 20 and 31 of the 1973 Constitution also discuss aspects of religious freedom. In particular, in Article 20, it is stated that for the reason of public morality or public order, legislation may regulate freedom of religion. This does not invest the legislature with unlimited power to impinge upon these constitutional rights. Lawmakers can act only in limited circumstances, which must pertain to public order and morality. Now, these aspects are important when studying the personal laws, which are almost always shaped by religion. More specifically, at the present day, about 51 family laws are enforceable in Pakistan. 37 laws are federal, while the remaining are provincial. About 16 laws deal with family matters related to Muslims, 3 to Christians, 11 to Hindus, 1 federal law to Sikhs and Parsis, while about 19 are applicable to all citizens with a few exceptions. Moreover, as you can see from the screen, other 7 laws deal with the right of divorced women, either directly or indirectly. In addition, a few weeks ago, after decades of delay, the Pakistani parliament passed a special bill legislating Hindu marriage, which grants the Hindu minorities the right to marry under their customs and register their marriage. From this point of view, it must be said that in general, Pakistan is now facing, in general, of course, a situation of inequality, discrimination, and insecurity. The impression is that the constitutional right to freedom of religion is often invoked to justify the freedom of religious communities only. In other words, cultural practices that are discriminatory towards certain categories of persons, for example, women and children, are justified by the autonomy of those communities. This often implies blind acceptance of religious customs or violation of basic human rights, including those, this is very important, including those referring to the Pakistani constitution that in matter of personal law is often ignored, not only with reference to the provision contained in Article 20, but also in respect of Articles 25 and 35, which, as you can see on the slide, empower the state to give special protection to women, children, and family. In addition, this system of personal law has played an important role in casting aside the religious minority from the public sphere and the political process, as if they did not exist at all, which is important of what just Jamal said. This is particularly the case of Hindu and the Christians. According to the last census, the Hindu are 1.5% of the population, the Christians 1.6%. According to the 1951 census, they constituted at least 12.7% of the population. So far as Bangladesh is concerned, according to the 2001 census, the large majority of the population is Muslim. Hindu constitute about 9.2%, but Buddhist 0.7%, and Christians 0.3%. Unlike Pakistan, which is named as the Islamic Republic, the Constitution of Bangladesh is supportive of secularism, which is one of the 4 fundamental principles stated in Article 8, which also includes nationalism, democracy, and socialism. In this case, you can also underscore some similarities with the preamble of the India Constitution. The most recent version of the Constitution of Bangladesh, however, begins with the Evocatio Dei, in the name of Allah, and contains rules regarding the declaration of Islam as the state religion. This ambiguous situation is even more exacerbated by the fact that the fundamental principles of Article 8, while necessary for governance, the making of laws, and interpreting the Constitution, quote, shall not be judicially enforceable, end quote, which leaves the reconciliation of the two principles, secularism and established religion, open to a wide degree of judicial interpretation. So, although the Constitution does not clarify what the state religion actually means, Islam plays a very important role in this legal scenario, especially in terms of the implementation of fundamental rights. On the other hand, these rights provide for equality before the law, the ban on unreasonable discriminations, equal protection of the law, and the equal opportunity with men and women in all spheres of the state and the public life. Under this point of view, it should be noted that the Constitution does not explicitly guarantee equal rights in the private or family sphere. Thus, in this context, the implications of secularism remain unclear, particularly in the field of personal laws, which generally have been treated as a matter of religious freedom. And like the Pakistani case, in Bangladesh, many times the freedom of religion has been seen as the right of a religious group to protect their traditions and rules, and not as a human right allowing individuals to develop their personality and autonomy, as Arif said, which implies the right to believe or not to believe, to change a religion, or to be free from a religion and the relative rules. It should be clarified that in Bangladesh personal law are a mixture of codified and uncodified rules. These codified and uncodified rules are subject to interpretation by the Supreme Court of Bangladesh and the High Court divisions, whose decisions become sources of law as well. Apart from the personal law, there are civil rules that apply to all religious communities. The 1872 Special Marriage Act is one of them, but as a family law expert note, in Bangladesh, this act is rarely used. This is also due to the fact that couples are often required to sign the declaration stating that they renounce their faith. In any case, Bangladesh has established a family court system to deal with personal law matters, both under the Code of Civil Procedure and the Family Court Ordinance. And the judicial activism in the form of public interest litigation has contributed to secure some women's rights. For example, significant judgments has been issued in petition of sexual harassment, forced marriage, guardianship, post-divorce, and maintenance. But women seeking justice for these rights in court also face obstacles. On the slide, you have some example of these obstacles. In many places, especially in the rural areas, couples seeking divorce, mar, or maintenance turn to community or village elders for informal mediation. This kind of alternative dispute resolutions has, of course, positive aspects. It is informal, close to home, and accepted in communities. Yet, it also has significant disadvantages. It is not bound by consistent procedures and legal standards, and sometimes it excludes women from fully participating in the process. Now, we should note that despite the obvious differences, the constitutions of both Pakistan and Bangladesh reflect the influence Islamist has had on the legal and political spheres. For example, both of the constitutions formally establish Islam as the state religion, and as I mentioned before, the independence of Pakistan and Bangladesh did not happen between two nations, only between the nation and other states. It was also a result of religious, social, and cultural conflict. In this context, the semiotic of Islam served as a marker for self-definition. At the present day, both in Pakistan and Bangladesh, many have called for reform in personal laws. Secularists, for example, want to introduce a uniform civil code on the Western pattern. On the other hand of the spectrum sit religious leaders who hold a more radical point of view. However, these two extreme positions are actually held by small groups, relatively small groups. Among them, there are the much more visible and politically powerful modernists and traditionalists. And in order to appreciate their positions, it is important to understand the role played by the British occupation, which was also a catalyst for identity politics, which I do think is quite interesting in the light of what Domenico Francavilla said yesterday about the tension or the interaction between uniformization and diversity, even within a single religious minority. Before the occupation, Muslim religious group, before the occupation, Muslim communities applied Islamic law differently. Muslim qadis, religious judges, took local customs into consideration while implementing the law. Essentially, the qadis were interpreting the law using independent reasoning. What in the Islamic, as you know, the Islamic tradition is called ijtihad, which means the human effort toward the best interpretation of the rules contained in the Quran and Sunnah. However, the British introduced a political institution, the colonial courts, which would alter this legal system. These new courts were an important part of the British administration. They served as a method of maintaining political control with minimal military involvement. Nevertheless, the new judicial system required intellectual effort, since the English judges were unfamiliar with religious laws in general and Muslim law in particular. They had to apply. So to simplify their task, the British found it necessary to create a more static and fixed Muslim law. From here, religion-based codified personal law came out. Personal laws came out. One result of this process of the codification was the false assumption that the religious laws were immutable. Another result was the essentialization of different legal systems and the creation of strong political identities shaped by religion. Moreover, in implementing the codification of religion-based personal laws, the colonial power was contributing to a paradigm in which these laws were not only solely divine, but in which real legal change could be molded by human hands. In other words, the British made reforms that sent out mixed signals to Muslims. On the one hand, the British codified the family laws, refraining from impeding on the majority Hanafi doctrine. This was a move toward suggesting the unchangeable laws of Islam. On the other hand, where the British Western sensibilities were offended, they introduced legislation to improve, for example, women's rights by altering Hanafi doctrine. This move suggested the flexible nature of religious law. In this manner, the British advanced the traditionalist agenda by placing the foundation for an ideology of codified religious law. Ironically, the British also advanced the modernist agenda by modifying and codifying rules that were supportive of women's rights, or, as Arur said yesterday, they at least leave the rule from legal interpretation. This explains why the move towards human legislative power nourished the tension between modernists and traditionalists. But this also explains why, at the present day, each group can look back at the British example to support their respective agendas as different as those may be. It's not by chance that today the fight over family laws turns on what exactly religious rules in general and Islamic rules in particular really are. Are they immutable rules, or are they changeable and open to independent and more rational liberal reasoning? More specifically, disputes about the definition of ijtihad serve now as the center point of the conflict between the traditionalist and the modernist. The modernists have been seeking to institute reforms while remaining within the legal regime based on religious law. In this case, ijtihad would allow for a more liberal interpretation of the Quran and Sunnah, also taking into account specific facts at hand. In this perspective, the modernists suggest that anyone, including secular judges, could practice ijtihad. On the contrary, the traditionalists have been developing the thesis that the unchangeable parts of the Quran and Sunnah must serve as the foundation of the Islamic community. In this sense, the traditionalist arguments are focused on the definition of ijtihad itself. To accept the all liberal modernist definitions would mean accepting that all rules, including those referring to the Western-based secular tradition, would be Islamic, and this is simply unacceptable from a traditional point of view. Now, these positions are important because they facilitate the task of evaluating the jurisprudence that since the 1960s have been taking a quasi-legislative role in the area of personal law. Yet, or maybe for this very reason, even in this case there is a tension between the secular family law courts and either formal or informal and religious courts. While the former try to follow a more secular code of the Western method of interpretation, the latter, for example, the Pakistani Federal Sharia Court, try to follow the Quranic text, Sunnah and the Hadith much more closely. At the same time, where traditional law may result in unacceptable consequences, both religious and secular courts normally use their judgment in order to achieve some sort of social justice. For example, many Pakistani courts, including religious courts, have tried to provide this goal while invoking Allah's prescribed limits, as if they push slowly for a secular reading of religion-based family law. On the screen you have a very important, I think, a recent example of that. It's about a decision from Peshawar High Court. And you can also appreciate here how the limits of God are used for affirming the women's rights. But, having said that, these modern judges, regardless if they sit on the secular court or the Islamic court, sometimes face opposition for informal judges who rely on fundamental Islamic doctrine. These judges attempt to resist the modernist legal theory by quoting Hanafi jurists and scholars. In this manner, they, for example, prove that a man has unlimited right to repudiate his wife, who, on the contrary, is not always entitled to have the marriage dissolved. In this case, the example is given by a recent declaration of the Pakistani Council of Islamic Ideology. In conclusion, all of this brings us back to the problem that, as a ghost, I think, has been hovering not in this room but in this faculty since the last year workshop. Indeed, these tricky questions, these very important questions, also involve India and Article 44 of its constitution. In this, as Professor Tognati said yesterday, in this context, in order to give people, especially the weakest and the defenseless, their proper place in society, do the existing religion-based personal law require modification, or are we forced to abolish them by adopting a secular uniform civil code? But as so often happens in my life, in this case I must confess that up to now, which means at this stage of my studies, I have no definitive answer yet. Thank you.
Well, thank you so much, Professor Alicino. Let me pick one particular, say, general transversal point to your talk. You mentioned many points the political projects over time, which would be identified by actors. You mentioned traditionalist and modernist. You mentioned the nationalist project after independence and the British project. So the project that some specific actors in a given time and context identified as the more desirable political project for the advancement of a given ideology for Pakistan first, and then Pakistan and Bangladesh since the independence of Bangladesh. And then you also pointed at effects. I remember this in particular with regard to the effect of the British agenda and the British political project turning out extremely contradictory in terms of outcome, favoring different constituencies or being open to interpretation for the sake of conflicting political agendas. Well, I think we have there an extremely interesting lesson to learn in terms of the not necessarily consistent correspondence and relation between a given political project and the effect and the outcome. The outcome of a political project can be extremely contradictory with what the tenets of that project had in mind. And I think that this we observe a lot in the discussion on personal laws and a uniform civil code. The discussion is about whether the relevant tool is the best instrument to achieve a given goal, but when we think of whether that tool is in fact instrumental to achieving that result, yet we don't know whether our speculation, whether our hypothesis will in fact turn out to be effective in society. And I think we are confronted here with both with both kinds of gap. A gap in theory, a gap in the formulation of the hypothesis, in the formulation of the political project, leading to some specific legal measures, and on the other hand, the gap between the project and results when it comes to the actual social practice. And I think that you were extremely effective in looking at this perspective with regard to the history, development with personal laws in Pakistan and Bangladesh. Thank you so much for giving us this overview, contributing a lot of interesting ideas for our discussion, while at the same time being so rich in the information that you provided. I think it's time now for our coffee break. I think we can resume at 11:10. Would that be correct? So coffee break is served, I suppose, where we had it already yesterday afternoon. So if we go out from this door, it will be left a floor up, and then what more? Left again, and the room and yeah on the on.
Just follow this man.
Okay. Thank you so much. We will resume at 11:10 for discussion.